thanks.
Yep. Actually, Daniel just went with him. When he comes back, I will have an extra one.
We're going to go ahead and get started. We've only got one bill on the calendar today, but we want to go ahead and move forward. And I have an appropriations subcommittee across the street that I'm going to excuse myself and turn the chair over to Vice Chairman Mumford, and hopefully I'll be back very, very shortly. But with that, we'll recognize Representative Levitas on House Bill 336.
Thank you, Mr. Chairman. And on your way out, I just want to thank you for the opportunity to be able to present this bill to the full committee. I know that the subcommittees and the committee has worked incredibly hard over the last several days of the quote-unquote recess, and I appreciate the attention that the committee's given this, particularly to Chairman Knox, who had to suffer through several variations of this bill. What I'm bringing before you today, I'm gonna break with tradition around here, and I'm not going to tell you that this is a simple little bill, because it's not. This bill is truly an overhaul of the existing DUI statute in the state of Georgia. We are sadly one of 5 states in the union that does not currently have a felony DUI statute. And I know we often like to be lockstep with our brothers in Massachusetts, but they're ahead of us on this one, as is California, as is Oregon, and as is just about everybody else. For those of you that don't know on the committee, I spent 5 years as a prosecutor in DeKalb County, and it was really through that experience that the idea for this legislation came to be important to me. And what I found, Mr. Chairman, is that I was seeing the same offenders who had been repeatedly punished as a misdemeanor for DUI offenses. And whether it was a vehicular homicide that came with it, a habitual violator, it was clear that they were being underpunished and that those sentences were not being enforced by the state. What this bill attempts to do is save lives, and I believe if I have a chance to explain it in detail and giving enough time for the committee to ask questions and let the other speakers address the committee, that it will become that I can do that. There is a death at the hands of a drunk driver in this country every 31 minutes, and 3 in 10 Americans will be involved in alcohol-related crash at some point in their lives. While in many of those states where felony DUI laws have been enacted, there is a trend downward in the number of fatal accidents. That is not true in the state of Georgia. Between 2003 and 2004, there were 31 states that declined in their alcohol-related fatalities, but not Georgia. During that same period of time, we actually had an increase of 8.7%. There is a sea of research out there that talks about how the repeat offenders pose a greater risk of death to other drivers on the road. A repeat offender is 8 times more likely to be involved in a fatal crash, and repeat offenders were found by a multi-year comprehensive study conducted by the Traffic Injury Research Foundation to be undermining the system at all levels. And I'm quoting from the study that DUI offenders, particularly by repeat offenders who avoid apprehension, prosecution, sanctioning, and supervision, undermine the system at all levels. About a third of the people arrested for DUI have got a previous conviction for the offense. In 2003, over half of the alcohol-related fatalities involved drivers with significant levels of impairment and repeat offenders. This bill is greatly changed from when I first introduced it. I have done my best to work and have worked with both members of the committee, and I appreciate their help with this measure. I have worked with the members of the defense community on this measure. I have worked with folks in DHR, with the district attorneys, talked to the judges, and gathered as much opinion and input as I could. And what I think we have here today represents a good compromise. It's one of those measures that doesn't have everything that anybody wants, but I think it represents a good step forward. In brief, what the bill will do is leave essentially a first offense the same. The punishments remain the same. The only error, for those of you looking at the flow chart, originally there was a proposal, and that remained on this flow chart inadvertently, to raise the fine from $300 to $500 as a minimum. That has been left at $300. There are two new requirements not in existing law, in that the first is to require a drug and alcohol evaluation on the first offense. Those are generally a $75 fee. The only further expense for those is if there's actually a substance abuse problem found and then further treatment's ordered. Keeping that in mind, however, I included a provision that exists in current DUI law and applied it to first offense that allows a judge to have the offense, the fine of a offender who is in a substance abuse treatment program. There was some concern expressed by members of the committee that if we require the offender to get a drug and alcohol evaluation, we'd be asking them to spend a lot of money on the first offense. So to the extent that that is a concern, the judge would have the ability to credit the offender for any expense that he has or she has in getting a drug treatment evaluation. The other provision that is not in current law is that there is a minimum requirement on the first offense for 120 days of an interlock device to be affixed to the car. While I would be glad to answer the questions of the committee in this regard, there are others here who are more expert in the placement of interlock and the use of interlock device here that can testify and answer that. I would just simply say that there is a great deal of data out there, and I'm happy to share what I have with the members of the committee that shows that interlock devices do reduce the number of repeat DUI offenses. Second offenses have an increased fine from $600 minimum fine up to $750. The drug and alcohol evaluation, the interlock provisions would apply to a second offense as well. The third and subsequent offense is really where the law changes. Originally, Representative Bearden and I who I thank greatly for his work on the bill with me, and I had a provision in there that related to individuals who had blood alcohol concentrations of 0.15 or higher, and how that might affect your status as a first offender or as a second offender. And because compromise is part of what all of us have to use down here in order to get our bills to move forward, we removed that provision. And I think, though I would have liked that provision in the bill, I think it's actually a little bit stronger now than it was going into it. The third offense becomes a felony, and you will see, for those of you that have the handy color chart, that they are treated differently if you pick up your third offense after 10 years or if you pick it up within 10 years. There is a minimum amount of community service required under federal law of 60 days for a third offense, and so those numbers reflect the federal statutes. The third offense after 10 years, it is a 1 to 3 year felony with a minimum time of 60 days in jail, and for a third offense within 10 years, it is a 1 to 5 year felony with a minimum of 180 days. For a fourth and subsequent felony, it's a 1 to 5 year with a minimum 1 year in jail and the 60 days of community service that's mandated by law. There are a few other provisions that I need to make the committee aware of that are not apparent from that chart. The first, and Representative Setzler, I don't believe he's here today, but he had raised some questions about subsection K of this current statute, which has to do with under 21 offenses by adult drivers who are under 21 years of age. his particular concern was with the .02 blood alcohol content. That is existing law, and okay, yeah. I'll move forward. All right. Thank you, Mr. Chairman. All right. The other provisions that the committee should be aware of. This does require, except for a first and second offense, that each and every day of the offense be served, and I'll get back to why that is, why there are exceptions for the first and second offense in just a second. There is a change to, I'm going to skip over subsection K and those changes. There is one change that is really more a technical change that's a new section 4 that was not at the subcommittee. And again, Ms. Travis is here now, and I want to thank her in particular. She's put in several hours fixing the I'll call it draftsmanship that I had, but really made this bill look better, read better, and she went through it, and I want to thank her for her hard work on it. One of the provisions that Ms. Travis noted was a current provision of the law that has to do with red striping licenses of folks that have been convicted. It really makes just a technical change to comply with the bill. It would not change when you pick up the red stripe. It just makes sure that we're no longer talking about 3 offenses in 5 years, and so it's really just a technical change. One other part of the bill that I think bears note is Section 5. This was one of the provisions that, after discussions with several parties, I agreed to as a compromise. And what this does is it looks back for the statute only back to 5 years. So if you've committed an offense in 1970 and 1980, it would not, for purposes of this bill, for purposes of punishment under this bill, count as an offense. The idea was to give people fair notice that from this point forward, if you pick up a third DUI at any point in your life, you are going to be considered a convicted felon and punished accordingly. There has been some concerns or questions, not really concerns, raised to me about will the DAs prosecute these cases? They're just misdemeanors right now. Are they really going to take them seriously? And I will let the prosecutors speak to that. All I can tell you is everyone that I have spoken with has said we have been waiting for this. And at the subcommittee, we had an assistant district attorney in Fulton County come here and testify about how long she's been waiting for just this kind of law to be in place so she could get a handle on it. The last thing I'll say about it before taking question, Mr. Chairman, is that the offenses, the first and second offenses, are left as they are as misdemeanors in order to give DUI courts a chance to succeed. My goal is that no offender will ever reach his or her third offense. That by the second offense, they're in the drug court, they're getting the treatment that they need, and the each and every day provisions of this bill would not apply to anybody enrolled in a drug treatment program or a similar substance abuse treatment program. And Chairman Knox was kind enough to work with me on some of those provisions, and I want to thank him for his work on the bill as well. With that, I will take any questions, Mr. Chairman, that the committee has on this bill.
Are there any questions from any members of the committee? I saw Ms. Abrams' hand first, Chairman. I'll get to you in just a second. She was in my line of sight.
Representative Levitas, I have 2 questions. Is there anyone on the panel who did not assist with the creation of this bill?
You know, I'm not sure that there's anybody in the State House that didn't assist in the creation of the bill at this point.
I got a clean record on this.
My more serious question is that, can you speak a little bit more about the concerns raised by at least one judge to me, which is that the structure of this bill will actually reduce the number of persons who go into DUI courts and thereby erode the effectiveness of DUI courts in the state of Georgia, which is a very effective program that we have now. Can you speak a little bit more about that?
Sure. And I would echo those comments that those drug courts, that the DUI courts are sort of a subspecies of the drug courts, and they've been very effective, and I would commend the judges that are running them and want to encourage them. As I explained, that's why we've left the first and second offenses as misdemeanors. There would be a minimal number by virtue of any offense committed within the last 5 years who might hit that felony offense. That said, the judge has a power, any judge has the power case where it is a 5-year, less a 10-year or less felony sentence, they could sentence that defendant as a misdemeanor, and it would not change their status as a felon. They could be sentenced as a misdemeanor, and they could impose conditions like a felony DUI court. I'm sorry, like a DUI court onto the conditions of probation. There will be a few people, and I say a few because you're talking about somebody who had to have committed their offense in the last 5 years, assuming the effective date remains where it is in the law. As to everybody else, everybody from 2002 backwards, they would, if your offenses occurred before then, you would be considered not to have actually committed an offense for the purposes of this law. But this bill will give drug courts and DUI courts an opportunity to do what they need to do, and it's important work, and I would not want to discourage it. As I said, my goal is to have nobody ever reach their third or subsequent offense.
Okay.
The other concern raised is that, and this goes back to your point that certainly prosecutors have been waiting for the opportunity and would indeed aggressively pursue these cases. The concern raised, though, is that if it's moved out of drug courts and the DUI courts into the general courts, that there wouldn't be the highly structured approach to treating the underlying illness of alcoholism that you find in DUI courts. Can you speak a little bit about what this would do to those high-risk offenders who are put in jail but are not necessarily guaranteed or given the type of structured approach and the structured treatment necessary to ensure that when they get out that they don't have a fourth or fifth because simply they never got the treatment they needed?
Right. Well, as I said, as to offenders who are in drug courts, they must have committed a prior offense. They're on their second offense. So I'm going to put aside all those and assume that every one of those will be either assigned to a drug court, a DUI court, or can have as a condition of probation some similar treatment program ordered as a condition of probation. And not only would a superior court judge have the same powers to impose as a condition of probation that an offender receive similar treatment as they do in a DUI court, but actually they're going to have a longer time to ensure compliance with the conditions of probation, because the lesser offense is a 1 to 3 year offense. So the court will have 3 years of probation to monitor a defendant in that case, and under fourth and subsequent offenses 5 years to monitor the performance and the conditions of probation. So my answer to you is that a court, because it is a superior court, is in no less of a good position to, and in fact I would suggest a better position, to monitor and impose conditions that are similar or more stringent than those being imposed by the DUI courts now. And I want to add one other thing. This is one of those offenses that would be a misdemeanor offense if it becomes a felony because of the number of times it's been repeated. And as a prosecutor, I handled shoplifting cases that were felonies. I handled domestic violence cases that were felonies, carrying concealed weapon cases that were felonies for their repeat offenses. I didn't, and I know of no other district attorney that decided not to take those seriously, or a misdemeanor attached to felonies simply because of the status of the offense. And I would suggest to you that this gives a very important tool to the criminal justice system, the administration of justice, to protect not only the lives of the person who that driver may hit and kill, or the family may hit and kill, but the drunk driver, him or herself, because if they are not able to stop themselves, and we're talking not about the third time they've been behind the wheel drunk, the third time they've been behind the wheel drunk and been caught and blown and been either determined less safe to drive or blown .08 or higher. At a certain point, we have to say we're going to take those folks off the road to protect other people and to protect them. At the same time, we're not going to give up on them. We're going to do the very best we can to make sure they get the treatment they want. But at the end of the day, my concern is to protect lives, and that's what I think this bill does, and that's been the missing element. We've got something now called a habitual violator statute, and I'm not at this late hour going to go into that except to say that it's a very highly complicated, unnecessarily complicated law. And even when you can get a judge to sentence in those cases, they don't serve any time and they're back out on the road. And I have personal experience with a person sentenced to 5 years as a habitual violator in jail back in my courtroom in a year. And that's why I think we need this law.
Any other questions from any members of the committee? Mr. Knox, Chairman, do you have a question?
No, sir, I'll pass.
I knew I could wear him down, Mr. Chairman.
No, I just saw the David McDade leave when you said the district attorneys were going to have to be happy about prosecuting more DUIs.
All right. sure this committee will endeavor to make Mr. McKay happy. All right, there's some other people who signed up to speak. Becky Vaughn.
Mr. Chairman, I believe she's here. Okay, I know she was on her way.
Thank you, Mr. Chairman.
Thank you.
I'm Becky Vaughn. I'm head of the Georgia Council on Substance Abuse, and I really appreciate the opportunity to speak before y'all, and also the fact that you're taking the time to look at an issue that has obviously become very serious in Georgia and is something we're very concerned about. We are a 501c3 nonprofit independent agency. Our mission is to reduce the negative impact of substance abuse on Georgia. We do that with collaboration, training, and education, specifically around treatment and prevention. Addiction is a disease very similar to diabetes, hypertension, and heart disease. Poor choices often bring it on. Personal responsibility is required to get well, and if left untreated, they are all fatal. But obviously, addiction has a serious impact on public safety. As you have heard from a great description, and we are so appreciative of Representative Levitas and this bill, House Bill 336 does have many provisions, but the single provision having probably the greatest impact on the consequences of driving under the influence is the requirement of clinical evaluation and treatment where indicated on the first offense. We worked very hard back in '97 to get this on second and subsequent offense, but we knew we were missing an awful lot of people at first offense. Study after study indicates, just like all of these diseases, that the earlier you can intervene, the more likely treatment will be successful. Evaluations are not expensive. The average in Georgia is around $120. It's very manageable, and with the provision that the judge can make adjustments, I think it is more than manageable. They are also very accurate in determining who needs treatment. But to wait until the second offense often puts that impaired driver on the road an average of 200 more times before he is caught again. The most effective way to stop the impaired driving and the overwhelming number of accidents and fatalities is to get people into treatment. Our best outcomes, as you heard, are coming out of our DUI courts and other mandated treatment settings. It is a myth that the people have to wait until they hit bottom to get well. You have a great opportunity today to make a real difference in the lives of thousands of innocent victims to drunk driving, as well as the millions of dollars that untreated addiction is costing Georgia. It will also make a tremendous difference in this person who you intervene with and get into treatment, as well as their family and everybody involved. I appreciate the opportunity, and if you have any other questions or need anything else from us, please don't hesitate to ask, and I would urge you to support this bill.
Any questions from the committee? From Ms. Vaughn, thank you very much. I don't see any. Larry Hannawalt. I would remind everybody the hour is late, and I don't think we need to be repeating each other. I know everybody on this committee's heard this bill about 4 times but me. So.
Thank you, Mr. Chairman, and members of the committee. I appreciate you holding this committee hearing on this important piece of legislation. I'm Larry Hannawalt. I'm a volunteer with Mothers Against Drunk Driving. My family has twice been victimized by drunk drivers. In 1978, my wife's older sister, Sue, was killed by a drunk driving crash while she was returning home from work. In 2001, our family was again victimized when my youngest brother was killed by a drunk driver. Since that time, my wife and I have both been active with MAD. My wife serves on the steering committee for the Cherokee County DUI Court, and we both speak at victim impact panels across the state. Georgia and the nation have made significant steps in reducing alcohol-related fatalities in the past 25 years, but we still have a long way to go. In 2005, 413 people were killed on Georgia roadways because someone made the unsafe and illegal choice to drive drunk. This bill contains 2 strong steps to help curtail this problem. The first step is to require ignition interlock devices for all drunk driving offenders. License sanctions have a strong deterrent effect, both in terms of deterring people at large from committing the crime and in terms of preventing people who commit the crime from reoffending. However, they are not enough. 50 to 75% of offenders whose licenses are suspended drive during the suspension period. Ignition interlock devices can prevent vehicles from being started when a person has alcohol in their systems. They're highly effective. Studies in Alberta, Colorado, Illinois, Maryland, North Carolina, Quebec, and West Virginia all showed that subsequent offenses decreased by 62 to 95% while the interlock was on the vehicle. Those areas that have applied interlocks for first-time offenders have similar results. New Mexico became the first state to require interlocks for all drunk drivers last year. They saw interlock implementation increase to 50% and saw their alcohol-related fatality rate decrease by 12% in the first year alone. Some say that this solution is too intrusive or too expensive. On the contrary, it represents a fine balance between taking away a person's license for too long, for letting them back on the road. This is a way that isn't punitive or unsafe, but allows an offender to maintain employment, get treatment, and otherwise reform their life while still keeping the rest of us safe. The second area on which we would like to focus are the repeat offenders. Nationally, 1/3 of those arrested for operating a vehicle under the influence are repeat offenders. These drivers are 40% more likely to be involved in a fatal crash than those without a prior DUI. This is a significant part of the drunk driving problem in Georgia. Repeat offenders are people who have exhibited, time and again, a disregard for the public safety. They've been given the opportunity to learn from that mistake and have put the public at risk. This bill addresses sentencing for those convicted 3 or more times as a felony. This is a high-risk offender. This bill is important from a psychological standpoint for offenders. They need to know that they cannot continue to do the same things over and over again and get the same misdemeanor sanctions. It is also important for the victims and those in the traffic safety community to know that drunk driving is a serious and violent crime and one that will not be tolerated. The goal is not to fill the jails or be punitive, but rather to deter people from committing the crime of drunk driving. What is new here, as you've heard, is not new. We're one of 5 states that does not have it. And I would like to say, members of the committee, that I know that there is no legislation that is going to bring back my brother or my wife's sister. But I believe that this legislation can prevent somebody else from going through the same heartbreak and agony that our families have gone through. I would be happy to take any questions that the committee may have.
Thank you, Mr. Hannawalt. Any questions? I don't see any. Thank you very much. Mr. Spahas.
Quickly, Mr. Chairman, the DAs and the solicitors have worked hard with Representative Leviticus on this. It's a good bill and both organizations support it.
Thank you very much. Any questions for Mr. Spahas? I don't see any. Mr. Dunbar? Mr. Dunbar here. Bonnie Reynolds.
Thank you for hearing me. I was a victim of a DUI crash in 202, and my son and I were traveling to the mall about 6:30 on a Monday afternoon, and he was 14 years old and he was killed. We were hit from behind, and it could happen to just anyone. And of course, everybody never thinks it will happen to them. But I'm just so glad that you are here at this time to make a difference for society, so these things cannot continue to happen to other people. And I just want to thank you for hearing me, and I'm thanking you very much for bringing this to our Georgia's attention, that it's something that needs to be reprimanded, that we need to understand that it is not just a misdemeanor to drink and drive. It is a serious thing, and the people that actually do it do not realize what they're doing, and they do need help for their families also. So thank you very much for hearing from me.
Thank you. Any questions for Ms. Reynolds? Yes.
I'd like to thank Ms. Reynolds. She's come up with my part.
Thank you.
So much.
Paul County.
Being down here, concerned with your job. Also,
I just don't want it to have anyone else.
I really did.
Thank you.
Thank you. Any other remarks? Any other further discussion? If not, what is the committee's pleasure on this matter? I recognize Representative Bearden for a motion.
Make a motion that House Bill 336, LLC number 29284-2S, do pass.
Is there a second?
Second.
All right. There's a motion and a second. Any further discussion? All those in favor of the motion, raise your right hand.
Chairman, why don't we vote?
I'm not sure you're allowed to vote.
Just in case.
I don't think you need to vote, so we'll record it as 5-5 unanimous. Yeah. All right, that concludes our business, ladies and gentlemen. Thank you very much.